get everybody back in here. House will please come to order. I'm going to need a majority floor leader to continue. Awesome. Mr. Majority Floor Leader.
Mr. Speaker, I move the House resolve itself into committee of the whole.
You have heard the motion. All those in favor say aye. All those opposed? Boy, that was not a lot of enthusiasm. Motion carries. Chairman Singh, come on up. Hey!
Committee of the Whole will please come to order. Before we continue, I'd like to take a personal privilege of the floor. If you direct your attention to the East Gallery, the West Gallery, I'd like to introduce my mom, Kathy Singh, to the House. Welcome to the House, Mom. I love you. The first bill for our consideration is Senate File 38. The reading clerk will please read the bill.
Senate File 38, sponsored by Management Audit. Financial Reporting Amendments 2, an act relating to financial reporting to the Department of Audit. Mr. Speaker, your committee number 2, Appropriations, to whom is referred Senate File 38 engrossed, Financial Reporting Amendments 2, respect the report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure? Representative Sherwood.
Thank you, Mr. Chairman. I move Senate File 38 and ask for your favorable consideration.
Point of order. First, you need a chairman or a vice chairman, and there's a different script to move a bill for committee of the whole than that.
What bill is it? 38. Senate?
You've heard the reading of the bill. What is your pleasure, Vice Chair Larson?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, that it do so with the recommendation that Senate File 38 do pass, and with the explanation bill, we turn the time over to Representative Sherwood.
Representative Sherwood.
Thank you, Mr. Chairman. This was a management audit interim topic. The bill amends the enforcement of annual financial reporting and audit requirements for our local governments and special districts that manage public funds. The current law requires our good auditor to withhold grant or state funds from any entity who is not in compliance with the reporting requirement. But it turns out that this was overly punitive and not feasible for the Department of Audit to manage. So we are coming to you with a correction. So page 2 of the bill directs the Department of Revenue to withhold monthly disbursements of state and local sales, use, and lodging tax from any county, city, or town that is not in compliance with financial reporting beginning on October 15th of each year until they are back into compliance. The withheld funds are retained in the account from which the disbursement would occur until the entity is in compliance, and then payments will continue. At the bottom of page 2, starting on line 21, this says our good auditor will certify to the Department of Revenue or confirm when a local government entity comes back into compliance. On the top of page 3, the Department of Revenue will report monthly to our auditor and to this legislative body on any non-compliant local governments, and then the amount of revenue that is being withheld because of the non-compliance. Starting on line 8 of page 3, this section directs our county commissioners via their treasurer and clerk to withhold any revenue for special districts that are not in compliance with reporting requirements as of October 5th of each year. On line 15, if by November 30th, so there's a little grace period, the district has still not come into compliance, the commissioners shall file a public notice in the local newspaper announcing that that entity is in danger of being dissolved. On page 4, lines 1 through 10, the special district will bear the burden of the cost of that publication of that notice, and the county treasurer shall withhold funds from the entity until the Department of Revenue certifies that they are back into compliance. Lines 11 through 17 outlines the process that the county commissioners will take to dissolve a special district if they are still out of compliance by December 30th. So again, another grace period. Lines 18 and 21 direct the county treasurer to report monthly to the auditor and to the legislative body any non-compliant special districts and the amount that is being withheld from them. On page 5, this clarifies a good clause provision that allows the Department of Audit to provide an extension for filing to local government entities, special districts. We heard during testimony over the interim that there is a shortage of CPAs, which means that not everyone is able to get their audit completed within the timeline that is allowed, so they can receive an extension. Line 19 repeals the requirement that our auditor is the one to certify, withhold funds, and notify which entities are not in compliance, and then moves that responsibility to the Department of Revenue for local governments, and moves the responsibility to the county commissioners for special districts. And with that, I will take any questions.
Is there any further discussion on the bill? Chairman Brown.
Thank you, Mr. Chairman. Ladies and gentlemen, this you'll see is a management audit bill, and as your vice chairman on that committee, this is a follow-up bill to what we had been discussing over the past couple of years, which is special districts. And you guys have already seen one of those bills that passed out of here this year to clean up some of the language that we passed last year about financial reporting. This is a follow-up bill to that particular situation. What we had going on is the department that handles auditing in our state came to us and said, look, we've got quite a few of these small districts that are just not reporting, and they're not following compliance orders. And so in a process of doing this, we just said, we want to make sure there's a carrot and a stick approach. And this is the carrot was to say, hey, look, get out there, make sure you're taking care of your duties and your responsibilities as an appointed or an elected official. The stick is this. Right? This is more of the, if you don't take care of what you're supposed to do, we're going to start withholding funds. And that's all we're trying to do here. We have these kind of going tandem. This was really, honestly, the commissioners did come and speak with us as well throughout the interim, and they were very supportive of this as well, because ultimately this falls back onto their shoulders. So I'd ask for your encouraged aye vote on this bill. This is a lot of hard work by your management audit committee. And if there are any questions, I do appreciate the good representative from over the hill working with us as well.
Is there any further discussion on the bill? Question being called. All those in favor of Chairman Larson's motion that when the Committee of the Whole rises to report, it does so with the recommendation that Senate File 38 do pass. All those in favor, say aye. Aye. And opposed, no. Senate File 38 has passed Committee of the Whole. The next bill for our consideration is Senate File 45. Chief Clerk.
Senate File 45, sponsored by Senator Nethercott. Vulnerable Adults Civil Cause of Action 2, an act relating to adult protective services. Mr. Speaker, your Committee Number 1 Judiciary, to whom is referred Senate File 45, Vulnerable Adults Civil Cause of Action 2, Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chestick, Crago, Haroldson, Jennings, Nemec, Oakley, Provenza, Rodriguez-Williams, Washit. Representative Washit, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Washit?
Thank you, Mr. Chairman. I move that when Committee of the Whole rises to report, to do so with the recommendation that Senate File 45 do pass, and I turn over explanation of the bill to the good representative from House District 55.
Representative Oakley.
Thank you, Mr. Chairman. So, members, I bring to you Senate File 45, and what this is an act relating to civil causes of action in relation to vulnerable adults, specifically when they're exploited. And what this bill does is creates that cause of action and expands the scope of who can bring the cause of action on behalf of the vulnerable adult. And I would say the need here, the problem we're solving is, of course, if you think about it by definition, and vulnerable adult is defined, they are not able, by very definition, that they aren't capable of bringing in action themselves. And so going to the bill, page 1 outlines that the type of damages. There's I guess 3 recoverable. The vulnerable adult may recover actual damages, that's 1. 2, it does allow for getting punitive damages. And then 3, reasonable attorney's fees. And then we go into, on page 2, which is really, again, the heart of the bill here, outlining who can bring this cause of action. So, adult's guardian, conservator, or the fiduciary. Number 2, the personal representative of the estate of a deceased vulnerable adult. You can read through these: agent, spouse, parent, descendant. And what we really had a lot of discussion on, so there's 7, 8, and 9. 8 says the vulnerable adult's caregiver or another person that demonstrates sufficient interest in the vulnerable adult's welfare. And so we had some discussion on that because people were concerned that this might be too broad about who's included in this. But I think the really important thing on this bill to understand is that if somebody brings the civil cause of action, they don't then become the beneficiary, or they're not going to get the benefits from them. There was concern about people, if it's too broad, somebody trying to, get a hold of the money, but they would have to bring it on behalf of the vulnerable adult. So there's just a lot less incentive, I guess, for nefarious action. But what there is it just opens up ways for these for this exploitative action to be recovered on. So that's what the bill is. And with that, I'd stand for questions.
Any further discussion on the bill? Question being called. All those in favor of Chairman Washit's motion that when the Committee of the Whole rises to report, it does so with the motion, or it does so with the recommendation that Senate File 45 do pass. All those in favor say aye. Aye. All those opposed say no. That bill passes. Senate File 45 passes Committee of the Whole. The next bill for our consideration is Senate File 47.
Senate File 47, sponsored by Appropriations. Law Enforcement Retirement Contributions, an act relating to compensation and benefits. Mr. Speaker, your Committee Number 2, Appropriations, to whom is referred Senate File 47, Law Enforcement Retirement Contributions. Respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Nicholas?
Thank you, Mr. Chairman. I move the Committee of the Whole rise and report. It does so the recommendation that Senate File 47 do pass. Turn the explanation over to Governor Rock Springs.
Speaker Pro Tem Stiff.
Mr. Chairman, thank you very much. Members, I encourage an aye vote on Senate File 47. This bill is practically an advertisement for law enforcement and law enforcement retirement. The retirement plan for law enforcement is a great plan. You can work for law enforcement for 20 years and retire at any age. It's a great, great program. Right now, it's 84% funded, 84%, which is not bad. But the problem with the fund is that it's on a downward trajectory. It's declining by about 1% per year. And so if we do nothing, if we do not pass this bill, if we do nothing, 30 years from now, it'll be at about 54, 55%. And that's not a good trajectory to be on. That's why this bill is here. The bill provides initially for a total of a 5% contribution increase, which would be split both ways. That was amended in committee, and Mr. Chairman, I would move, to explain that, Mr. Committee, I would move Standing Committee Amendment Number 1 to Senate File 47.
You've heard the motion on Standing Committee Amendment Number 1. Is there any discussion on the amendment? A question having been called, all those in favor of Standing Committee Amendment Number 1, say aye. Aye. Opposed, no.
Mr. Chairman, thank you very much. So here's what we're doing. In the bill itself, it had a proposed 5% increase, and it turns out that after 30 years just gets you to 95%. It doesn't quite get you there. And the other thing about the bill is that the bill was going to have it occur immediately, like all 5% would go into effect right away. And the law enforcement agencies, and again, this includes for example, the correctional officers, the Department of Corrections would be an example of persons covered under this plan. They asked if we could phase it in. And so what the Standing Committee Amendment does is it phases it in over 3 years. And we've increased it very slightly so that at the end, instead of increasing it by 5%, you're increasing the contributions by 5.4% at the end of 3 years. And if you do that, what you get to in 30 years, you get to 98% funded. And we thought that was close enough. As far as how the fund works, it's not just state law enforcement officers who are in this plan. Actually, there are only 21% of the participants. 43% are county correction, law enforcement, so sheriffs, deputy sheriffs. 34% are cities, your local police department. So what is the impact of this? Right now, it does mean that the law enforcement officers, they will be actually making a contribution. Their contribution at the end of 3 years will be 2.7%. That compares with the contributions by state employees for the big plan. They're contributing 3.68%, okay? So it's still better to be in law enforcement than to be a regular state employee in terms of your out-of-pocket cost. There is an out-of-pocket cost, though, that they'll see. It phases in, and it's about $65 a year from the first year, and then it goes up, and then at the end of the day, you're just right at it's about $190 a month. It comes out to, the end result is almost exactly $2,000 a year that they will be paying out of pocket to make this fund work. But it's a great plan because what they're doing for every dollar of contribution to the plan, the law enforcement officer is putting in 12 cents. So it's a great deal. You put in 12 cents individually, you as the law correctional officer, say at the Department of Corrections, you put in 12 cents, you get $1 of contribution for that 12 cents you've just put in because the state's making up the difference. And then when you retire in 20 years, because of the growth and the magic of compound interest, your benefit, you're getting $3 of benefit for that 12 cents you put in. So it's a fantastic deal. Again, this 12 cents for law enforcement officers compares very favorably with the state pension plan, where they're putting in about 21 cents for every dollar of contribution. So it's great to be a law enforcement officer in Wyoming. Please vote aye. Oh, Mr. Chairman, I believe we may have a committee of the whole amendment as well.
We are now on Committee of the Whole Amendment Number 1.
Thank you, Mr. Chairman. Members, I caught a technical error, so I'm going to withdraw Committee of the Whole Amendment Number 1, get that fixed and bring it back later. Thank you.
Okay. Committee of the Whole Amendment Number 1 has been withdrawn. We are back on the bill. Is there any further discussion? Chairman Washut.
Thank you, Mr. Chairman. Just a quick question. The other day, we passed a provision for the gold standard on retirement investments, and we were told that was going to shrink the timeline by half. Can you explain why this is still 30 years?
Representative Stith.
Mr. Chairman, yes, and I'm not an actuary by trade, but the actuarially determined contributions bill that we had before, that applies to the big plan, to the state pension plan. It does not apply to this smaller law enforcement plan. So they're on separate tracks. I mean, we have not yet come up with an actuarially determined contribution bill for this one, but that may be in your future. If you did do it that way, by the way, just for fun, the analysis on that is, because that was presented to us, if you did so-called actuarially determined contributions, instead of paying 5.4%, the law enforcement officers would pay 6.21%. So it'd be a little more expensive, is the estimate.
Representative Ottman.
Thank you, Mr. Chairman. Just a question for the bringer. Growing up in the days of corporate America and growing in retirement and benefits and also state plans and Social Security, what I'm wondering about, because of course I support law enforcement and want them to have good benefits. But where my question is as we look at this actuarially, if you're looking at putting more and more people on a program where they in 20 years can retire, there will be people collecting more because they could be retiring at 40 and live another 40 years, and people putting in the 12 cents or whatever and taking out. So what I'm wondering about all of this is that, is this going to be something that continues to have to be funded because we're always at 80%, 78%, 65%? Thank you.
Representative Stith.
Mr. Chairman, it's a great question. It is a unique feature of this retirement plan that you can retire so early. Some of the other plans, minimum retirement age is, say, 50, or there's a rule of 85 for some of these. That was discussed, but law enforcement is slightly different. It's more of a, in some ways, a young person's game. In that when someone calls for their local law enforcement to come rescue them, they don't want someone like me showing up. They want someone younger and more agile and fitter. So Mr. Chairman, I believe that what this does is it, according to the actuary who testified, this puts the plan, instead of being on a downward trajectory, this puts it on an upward trajectory.
Representative Ward.
Thank you, Mr. Chairman. This is going to be a similar question to what I asked the other day. Is there any thought of moving new employees on this plan to a defined contribution plan instead of a defined benefit plan? Defined benefit means pension. Defined contribution is a plan like a 401k. If I were a new employee, I would much rather be in charge of my own retirement than have the government in charge of it. So is there any thought that we could move in that direction?
Chairman Brown.
Thank you, Mr. Chairman. Just a question. I noticed this is a joint bill that was brought forward, and I noticed that the House has amended this stair-step function into it. I'm curious what the discussion was, if there was this discussion prior to this as a joint committee and it just failed, and so we're going to send that over and we're going to ask for a conference, or do we expect that this will likely come through and get settled out? I mean, to me, as I look at this, I see that we're taking a pretty drastic change compared to what the Senate had on there. So just some questions on some discussion there.
Representative Sherwood.
Thank you. Just to assist in helping the question, during testimony, your House appropriators heard that there was concern that because we have a lot of vacancies in our dispatchers positions and they just got a bump, right? Slightly competitive, you can still make more money somewhere else, that by doing this all at once, that increase, that we were gonna hurt our dispatchers. And so we were very thoughtful in hearing that testimony and did this phase-in option to make sure that we're taking care of those who are connecting us to law enforcement services. Thank you.
Chairman Nicholas.
Thank you. I'm on in favor of the bill, ladies and gentlemen. So law enforcement was there, both in our interim committees and just recently when it came back to the House, all 100% in support of these amendments. And you'll hear this again, because this isn't the only bill that does this type of thing. But our obligation is to make these funds sound and on a positive trajectory. Otherwise, someone else in the future will be bearing the cost of these folks. We have over many years have discussions between defined benefits and contributions. The problem with that concept at this point is that we're way too far down the road. And whenever we do have those discussions, most, if not all, the employees do not want a defined contribution. They want defined benefits because it is a better program for them, and it's less expensive for the state. But one of the ways that we capture and retain law enforcement and state employees is because of frankly, of our retirement programs. We have good programs, but we just have to maintain them at a level that sustains us for the next 30 years. And so I'm on in favor of the bill and the amendments.
Is there any further discussion on the bill? Are you ready for the question? Question being called. All those in favor of Chairman Nicholas's motion that when the Committee of the Whole rises to report, it does so with the recommendation that Senate File 47 do pass. All those in favor say aye. Aye. Those opposed, no. No. Senate File 47 has passed Committee of the Whole. The next bill for our consideration is Senate File 48. The reading clerk will please read the bill.
Senate File 48, sponsored by Appropriations. Patrol, Warden, and Investigator Retirement Contributions, an act relating to compensation and benefits. Mr. Speaker, your Committee Number 2, Appropriations, to whom is referred Senate File 48, Patrol, Warden, and Investigator Retirement Contributions, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stiff, Walters, Swanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Nicholas?
Thank you, Mr. Chairman. I move the Committee of the Whole rise and report. It does so the recommendation that Senate File 48 do pass. And I'll turn the explanation of the bill to the good representative from the round of the Rocky Springs.
Representative Stiff.
Mr. Chairman, thank you. Members, this is very similar to the bill we just discussed, except instead of being for law enforcement, this is for the highway patrol wardens and investigators. It's a pretty small plan. There are just 272 members in this plan right now. And as with our law enforcement plan, it's not that the funding ratio is bad now. It's about 80.6% right now, but the problem is it's on a downward trajectory. What this bill does is it takes the total contribution takes the contribution from 14.65 up to 18.92%. But the employee share of that is just 0.39%, and that comes out to $31 a month. So yes, the Highway Patrol will be paying an extra $31 a month, but instead of the plan being depleted, you get to full funding, 100% funding, according to the actuaries, by the year 2051. So on and forward, I would stand for any questions.
Is there any further discussion on the bill? Are you ready for the question?
I'm not ready.
Oh, Chairman Olson.
Yeah, thank you, Mr. Chairman. To the good appropriator, I noticed in the bill title of the bill, it talks about archaic provisions being stricken. What in the world is that? Is it therefore without the E or?
Representative Stiff.
Mr. Chairman, let's look through the archaic provisions that are being stricken. Don't see any on page 1. Don't see any on page 2. The, and I could request assistance from a fellow member.
It's all these old dates.
Mr. Chairman, yes, it is on page 2. So we have on page 2, you'll notice as lines 3 and 4, that we have reference to the period from September 1, 2013 through June 30th, 2014, et cetera, et cetera. So thank you so much for the question.
Is there any further discussion on the bill? Question being called. All those in favor of Chairman Nicholas's motion that when the committee of the whole rises to report, it does so with the recommendation that Senate File 48 do pass. All those in favor say aye. Aye. All those opposed, no. Senate File 48 has passed committee of the whole. The next bill for our consideration is Senate File 49. Reading clerk will please read the bill.
Senate File 49, sponsored by Appropriations. Judicial Retirement Program, Contributions, an act relating to compensation and benefits. Mr. Speaker, your committee number 2 appropriations to whom was referred Senate File 49 engrossed. Judicial Retirement Program Contributions. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Swanitzer. Representative Nicholas, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Nicholas?
Thank you, Mr. Chair. I move in committee whole rise and report. It does so the recommendation that Senate File 49 do pass, and I'll turn the explanation over to the good representative from over the hill.
Representative Sherwood.
Thank you, Mr. Chairman and body. So again, over the interim, your JAC worked with the state retirement system on these series of bills to make sure that we are making appropriate adjustments to our retirement plan contribution rates. So this is for the judicial branch, and these rates have been in place since July of 2008. So this plan covers the Supreme Court, our district court judges, and our circuit court judges. Because the current contribution rates are not enough to cover the normal cost of the plan, so there's a slight decline. There is now in this bill an increase of 2.25% over the current 9.22% rate in contributions. And this is to ensure that we get the plan back on track in the next 15 years. The contributions are split between the employees, it's 15.4%, and the employer at 84.6%. The increased employee cost is estimated at $651 a year or $51 a month. There is an appropriation of $420,000 from the general fund to cover the Supreme Court share of increase in contribution rates for fiscal years 25 and 26. And therefore, after continuing on, the appropriation will be included in this court's standard budget request. And with that, Mr. Chairman, I stand for questions.
Question being called. All those in favor of Chairman Nicholas's motion that when the committee of the whole rises to report, it does so with the recommendation that Senate File 49 do pass. All those in favor say aye. All those opposed, no. Senate File 49 has passed committee of the whole. The next bill for our consideration is Senate File 60. Reading clerk, please read the bill.
Senate File 60, sponsored by Select Federal Natural Resource Management. 2024 Large Project Funding, an act relating to the Wyoming Wildlife and Natural Resource Funding Act. Mr. Speaker, your committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom is referred Senate File 60, 2024 Large Project Funding, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Angelos, Burkhart, Byron, Larson, Newsom, Singh, Storer, Western, Winter. Representative Newsom, Chairman. This Senate file was re-referred to Committee Number 2 Appropriations. Mr. Speaker, your Committee Number 2 Appropriations, to whom is referred Senate File 60, 2024 Large Project Funding, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Swanitzer. Representative Nicholas, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Newsom?
I move that when committee of the whole rises to report, it do so with the recommendation that bill SF 60 do pass, and I turn the explanation over to the good country lawyer.
Representative Crago.
Thank you, Mr. Chairman. Members, I bring to you Senate File 60, the 2024 Large Project Funding Bill. This bill is a product of the Select Natural Resource Funding Trust and the committee that's associated with that. It then runs through our Select Committee. This particular bill has 3 projects in it. Those projects are a fish passage in Park County, restoration of native plant species to enhance wildlife habitat in Carbon County, and a vegetation management and invasive species control project in central Wyoming, Natrona, northern Laramie, northern Albany County, excuse me, project. And the cost of each of those projects is set forth in the bill. They're pretty straightforward. If you look through the bill, it tells you exactly what each project does, what the purpose of each project does, and I won't get into specifics, but if anybody has any questions about the bill, about the process, or what the trust does, just feel free to step up to the mic. With that, I'd stand for questions.
Is there any further discussion on the bill? Oh, Representative Hornock.
Thank you, Mr. Chairman. Yeah, a question. So we appropriated in our budget, I believe we were up to $10 million for grassland invasive species stuff. How does this relate to that? Are they connected? Is this separate from that? So this is an additional, I think it was $3 million or whatever it is in this bill. But could you just talk about that connection, if there is one?
Representative Craigo.
Thank you, Mr. Chairman. So there is a connection, but they are unrelated as well, and I'll explain how. So this is the standard. This bill contains the standard projects that run through the trust and through the committee, which have been vetted by the committee. That the committee then makes proposals to the Select Legislative Committee. And that, there's 9 members on that particular board stationed around the state that know their particular communities. What the additional 10 million did for attacking invasive species was an add-on to this to address a specific problem outside of the normal processes. It will eventually go through this process. It will go through that 9-member board to decide how they are going to spend that money, but it's not part of this bill. And so that's why I said they're not connected, but they are on the backside, and they will go through the normal process at some point.
Is there any further discussion on the bill? Question being called. All those in favor of Chairman Newsom's motion that when the Committee of the Whole rises to report, it does so with the recommendation that Senate File 60 do pass. All those in favor say aye. All those opposed? Senate File 60 is passed Committee of the Whole. The next bill for our consideration is Senate File 81. Reading clerk will please read the bill.
Senate File 81, sponsored by Senator Baldwin. Hospital or healthcare district created entities, immunity, an act relating to civil procedure. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 81 engrossed, hospital or healthcare district created entities, immunity, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chadwick, Clouston, O'Hearn, Yen, Swanitzer. Noes, Representatives Hornock, Penn, Trujillo, Ward. Representative Swanitzer, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Swanitzer?
I move in the Committee of the Whole rise to report to do so. The recommendation that Senate File 81 do pass. There are understanding committee amendments. And apparently I'm going to present the bill to you. Nope, apparently I'm not. I'm going to turn it over to the good representative from the land of the camels.
Representative Clouston.
Thank you, Chairman. Ladies and gentlemen, this bill comes to us as a cooperative agreement between the county that I live in and county to our west on the most northern part of our state. What this is several of our government agencies have immunity. So our hospital has its own immunity. The hospital in the other county has immunity, and they formed a working group together. But it's not clear in the law if these two groups together, as they form a new entity, also have that same immunity. This agreement has worked out very well. We've heard from the other county that having the ambulance service from our county has helped save lives. It's very important to them. By not having this in law right now, both of these county facilities are having to pay increased insurance costs. So what this bill is really doing, it's a short little bill, but it's just providing in law that when two government entities that have immunity form a common group, that immunity goes with them. I stand for any questions.
Is there any further question being called? All those in favor of Chairman Zwanitzer's motion that when the committee of the whole rises to report, it does so with the recommendation that Senate File 81 do pass. All those in favor say aye. All those opposed, no. Senate File 81 has passed committee of the whole. The next bill for our consideration is Senate File 12. The reading clerk will please read the bill.
Senate File 12, sponsored by Agriculture. Meat processing plants, hides, and carcasses. An act relating to hides and carcasses. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred Senate File 12, Meat processing plants, hides, and carcasses. Respectfully report, same back to the House with the recommendation that it do pass. Ayes. Representatives Alleman, Allred, Banks, Conrad, Crago, Davis, Eklund, Slagle, Winter. Representative Eklund, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Eklund?
Mr. Chairman, I move that when the committee of the whole rises to report, it do so with recommendation that Senate File 12 do pass, and I'll turn the explanation of the bill over to our young colleague from very nearly Montana.
Representative Banks.
Mr. Chairman, thank you. So Senate File 12 was something we worked in the interim with the good board that oversees our livestock, and they had a request for us to fix in statute that deals with brand inspections on these hides and carcasses. So currently what happens is when you're taking a cow to slaughter, you have to have an inspection before it's taken. And then if you want to get rid of that carcass or that hide, you have to have a second brand inspection. So what this does is take away that second brand inspection so that the processors can dispose of those hides or those carcasses. There is no really current market on hides right now. They're not valuable. So the ability for these processing plants to get rid of these hides really is, as testified by the livestock board, that second brand inspection is really not needed. And so this is just a real quick cleanup bill in those statutes to aid our department that oversees livestock. So ask for your aye vote.
Is there any further discussion on the bill? Representative Newsom.
Thank you. I just have a question, having spent a little bit of time as a meat inspector, and that we did have the cattle come in and brand inspected, and then before the hide buyer got the hides, they were inspected, and I was always under the impression that there should not be a hide in the hide pile that had not gone through the inspection of the live animal, and that's why that check and balance was there. And so I'm not sure how this helps that, because if a slaughterhouse would kill an uninspected cow, and then that hide would show up in the hide pile for the buyer to buy, that was when I was under the impression that that second brand inspection, that second hide inspection would shortcut somebody killing cattle that are not brand inspected before they're killed. So I'm a little confused as to why the hide inspection is not important.
Representative Berger.
Thank you, Mr. Chair. Just a quick question for the good bringer. If the prices go up, will we have to come back and change this?
Representative Banks.
Mr. Chairman, thank you, and thank you for that question. So the process now is we don't currently, that was testified to us, have a hide buyer here in the state of Wyoming. So when the hides go out of state to a buyer, they have to pass that inspection. They have to be inspected to go out of state. And so we felt that having that inspection to go out of state was already covered under existing statute.
Is there any further discussion on the bill? Representative Jennings.
Thank you, Mr. Chairman. So I think I'm going to follow up on that question just a little bit. Why was this initially put in place? Before we get rid of it, maybe we should know why we initially had two.
Any further discussion on the bill? Chairman Eklund.
Well, the last question I'm not sure of, other than it's a precaution. Each time there's a brand inspection and a brand inspection's issued, it changes, usually is to change the title of the livestock. So it's a title transfer. The chairman of travel, to answer her question, yes, it does have to happen, that there has to be an inspection of the live animal, and that results in a title transfer that usually goes to the processor. Not all the time, but usually. So it's a title transfer. Probably, I think the answer to the last question would be so that there's a good trail of evidence as to where these cattle have gone and been. And if you've ever sent cattle, the reason this is so important, these brand inspectors are, in my mind, if you've ever sent cattle very far east, you run out of brand law. And to me, it would just be a free-for-all if you sent cattle there and wondered if you'll ever get them back, because they don't track them in any way. The other part of what we do also is they're able to track disease and other things. So it's an important tool that's used in Wyoming to keep the herd healthy and keep track of diseases that could be scattered about.
Speaker Summers.
Mr. Chairman, thank you. So my question is, kind of before you signed a bill of sale for the hide to the processor, and that was how you got rid of the hide, and he could do whatever he wanted with the hide. We never really, you never really sold the hide to the processor. And so what happens in the state of Wyoming if you have somebody that wants hides, like, some little outfit that wants to tan some leather and make some products? Does that mean then that the owner of the cow would have to be the one that sold the hide? Because at that point, then the hide isn't belonging to I assume isn't belonging to the processor. That's my worry. And let's be honest, this was put in place originally to stop theft. So somebody didn't haul your cow into the meat processor in another county, butcher your cow, and then the evidence was ultimately the hide. And if the hides didn't all match up, well, then somebody did something wrong. So I'm just trying to make sure you got it all in a manner where we're not going to open back up for theft.
Representative Banks.
Mr. Chairman, thank you. Yeah, to answer that question, on page 2 there, you read where the bill of sale accompanies the hide. And that hide, it says, shall be available for inspection by, our brand inspectors, our sheriff deputies. So when the hide is sold, a bill of sale will accompany the hide. And it does, and so that ownership is transferred through the bill of sale at that point and will accompany that hide wherever it would end up. I hope that answered that question.
Is there any further discussion on the bill? Question being called. All those in favor of Chairman Eklund's motion that when the Committee of the Whole rises to report, it does so with the recommendation that Senate File 12 do pass. All those in favor say aye. Those opposed? Senate File 12 has passed Committee of the Whole. The next bill for our consideration is Senate File 18. The reading clerk will please read the bill.
Senate File 18, sponsored by Tribal Relations, Indian Child Welfare Act, Safe Haven Amendments, an act relating to children. Mr. Speaker, your Committee Number 3, Revenue, to whom is referred Senate File 18, Indian Child Welfare Act, Safe Haven Amendments. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Zwanitzer. Representative Oakley, Vice Chairman.
You've heard the reading of the bill. What is your pleasure, Vice Chair Oakley?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 18 do pass, and turn over the explanation to the good chairman of the task force that deals with this law.
Representative Larson.
Thank you, Mr. Chairman. Bring to you Senate File 18, and just would refresh your memories. Last year, we had, about this time of the session, we had a conversation on the Indian Child Welfare Act, which had been created in the 1970s, which was pending action in the Supreme Court, referred to in a special case. And we brought in, there was concern that the Supreme Court might overturn the Indian Child Welfare Act, referred to as ICWA. And we brought in to our state statutes those federal regulations and codify state ICWA law. During the course of the Supreme Court hearing, the ICWA, the Indian Child Welfare Act, was upheld. So the federal law still is in place and governs. We had created a task force at the end of last year to, in the event that we needed to adjust or make corrections in the state Indian Child Welfare Act statutes. And we met several times with members of the two tribes, Northern Arapaho, Eastern Shoshone, district attorneys and agencies and legislators. And we found two things. We're going to hear two bills on our state statutes that we need to fix. The first one was brought up by the department that handles our child protective services and adoptions. And they noted that after the Indian Child Welfare Act was created, the Safe Haven Act was created. And you'll recall that we had a discussion on safe haven statutes with House Bill 90, I believe, where we are looking to extend the length of how old the child can be from 14 days up to 60 days, I believe. And that's down on the other side being heard now. The Safe Haven law didn't contemplate or didn't address any of the ICWA provisions. And you'll recall that in the Safe Haven law, that when a child is relinquished, that it's presumed that there's no neglect or abuse, and that there's not a lot of questions that take place. The concern is if that child happened to be of Native American ancestry or tribal blood, that the ICWA law should perhaps apply. And so we discussed that, and we made changes in 1411-103D, which is in the Safe Haven statutes, that require the Safe Haven provider shall ask the parent or the parent's designee whether the child has any tribal affiliation or Native American ancestry, and request relevant information to determine the child's tribe. The Safe Haven provider shall not require that information be given or the person relinquish express an intent for return of the child. So they're going to be required to ask, and then it will be up to the parent or the person relinquishing the child if they want to provide that information. And if it's determined that the child is has a tribal affiliation or Native American ancestry, then they would need to comply with the ICWA statutes and notify that child's tribe. And so with that, I'd answer any other questions.
Is there any further discussion on the bill? Representative Hornock.
Thank you, Mr. Chairman. I do have some questions on this. I'd like some clarification. So in our current statute, the reason why we have the ability to relinquish newborns, and it's almost under a certain amount of anonymity. Whatever the cause may be, somebody is allowed to take their newborn to the fire department or the police station or something and relinquish that newborn almost with no questions asked, because they understand that they can't take, for whatever reason, they can't take care of it. It comes from a bad situation, whatever the situation may be. So we have those laws in place for that reason, for the anonymity, to be able to do this for the protection of the child. And now in state statute, we're putting a clause in there that says shall. So whoever's taking that child now shall, they're required to ask a question about the ancestry of the child. And it may be a thing, it may not be a thing for this particular child, but if we put in state statute, they are required to ask this question. We're dealing with law enforcement agencies, we're dealing with volunteer firefighters, we're dealing with those kind of possible scenarios. Do these guys know and understand that they are required to ask this kind of a question? And if they don't ask this kind of a question, then what? Are they then criminals, I guess? So that's the first thing I'd like clarification on. And this throws in something which basically takes away the anonymity for a parent who wants to give up their child, which is a big decision to do. And then the second point of clarification I would like is in 1411-105, since we have the ICWA law in place, isn't this already a given? Thank you.
Chairman Larson. Sorry, Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Questions? I had the same concern as a previous speaker, but a few more. Under 1411-103, D, E, and F, we use the word may. Under D, it says the parent or parent's designee may provide information regarding the parent and newborn child's medical history, etc. Under E, a safe haven provider may provide any necessary emergency medical care. Under F, a hospital receiving a relinquished newborn child may provide, etc. But my biggest concern is D. We talked a little bit about anonymity, but one of the beautiful things about relinquishing a newborn child, aside from the anonymity, is the no questions asked. The goal of it is to save babies from unsafe abandonment. And so often when a baby is relinquished and turned over to a safe haven provider, they do it with anonymity and without saying anything. Thank you.
Chairman Larson.
Those are really good questions, and they're exactly the questions that we wrestled with in the task force, because the questions that were presented by the two representatives at the back of the room are exactly right. Safe haven is to provide a very unintrusive environment for that child to be relinquished if that is the cause of or the need of the parent or the guardian being presented there. So you've got that. And I think we recognize that. On the other side, you've got this provision, the Indian Child Welfare Act, that says that a child who has tribal affiliation or Indian ancestry has a right to be known and to have an involvement and affiliation with his tribe or with tribal family. So how do we accomplish both? How do we get there without one stepping on the other, without our current law, which says you can have total disregard for ICWA, and with imposing the requirements of ICWA without stepping on this and being too intrusive. And so we thought that the approach that we took there by the agency, and the agency felt that was a responsible approach, as did the tribe. Now, if you were a governing a tribal council, you would maybe look at this language and say, not only shall they be required to ask, but the person they're asking shall respond. And they acknowledge that in this condition is not. And so they're required to ask, but the person is not required that any information be given up. So we tried to thread that needle to where they didn't have to provide any information, but they had to be questioned. And similar to what was noted further down there, that in our existing statute, that the parent or the designee may provide information, so they may provide it now, and that hasn't changed. We're just requiring the safe haven provider to make that inquiry. Now, the question and the concern that those individuals at the safe haven location, are we putting an undue burden on them? If they're a designated safe haven facility, they're taught what their responsibilities are for accepting these children that might be relinquished. And so I think that training will take place. I'm confident and comfortable that it is, and be happy to answer any more questions.
Representative Byron.
Thank you, Mr. Chairman. A few days ago when we heard these two bills, this next bill as well, coming in committee, we had all positive testimony. I think what's really important to note is members and representatives, both in person and on the Zoom, were very positive about this and supportive of this bill. So as the body considers this vote during COW, I think it's important to note that those that are directly affected by this gave positive supporting testimony in favor of moving this forward.
Is there any further discussion on the bill? Question being called. All those in favor of Vice Chair Oakley's motion that when the committee of the whole rises to report, it does so with the recommendation that Senate File 18 do pass. All those in favor say aye. Aye. And those opposed, no. Senate File 18 has passed, Committee of the Whole. The next bill for our consideration is Senate File 37. Reading clerk will please read the bill.
Senate File 37, sponsored by Tribal. Indian Child Welfare Act, Delinquency Amendments, an act relating to domestic relations. Mr. Speaker, your Committee Number 3 Revenue, to whom is referred Senate File 37 engrossed, Indian Child Welfare Act, Delinquency Amendments, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Baer, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Zwanitzer. Representative Oakley, Vice Chairman.
You've heard the reading of the bill. What is your pleasure, Vice Chair Oakley?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 37 do pass, and turn over the explanation to the same good chairman.
Chairman Larson.
Thank you, Mr. Chairman. And this is another cleanup in the Indian Child Welfare Act, where when the bill was being put together, instruction was given to staff to bring in any of the statutes that currently pertain to protective services or the Juvenile Justice Act. And in doing so, what we did is we put the requirement for any child that's been convicted of delinquency to comply with the ICWA law. So what that would mean is if you had a child that was arrested, was adjudicated as being a juvenile delinquent, that then the requirement would be to, if that child's tribe lived in a neighboring state, maybe like we see up in to the north of us and to this east of us, that then you would have your district attorney then contacting the tribes in another state to talk about their opinion on this charge. And it, as you can see, that doesn't work real well because you have two different jurisdictions, could have different laws. And nowhere in the federal or in the federal ICWA law does it talk about the delinquency provision. And so we want to pull that delinquency provision requirement out and make that effective immediately. And I'm happy to answer any other questions.
Any further discussion on the bill? Question being called. All those in favor of Vice Chair Oakley's motion that when the committee of the whole rises to report, it does so with the recommendation that Senate File 37 do pass. All those in favor say aye. And those opposed, no. Senate File 37 has passed the committee of the whole. The next bill for our consideration is Senate File 55. The reading clerk will please read the bill.
Senate File 55, sponsored by Revenue. Board of Equalization, questions before the board. An act relating to the State Board of Equalization. Mr. Speaker, your committee number 3, Revenue, to whom is referred Senate File 55. Board of Equalization, questions before the board. Respect the report, same back to the House with the recommendation that it do pass. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Swanitzer. Representative Harshman, Chairman.
You've heard the reading of the bill. What is your pleasure, Vice Chair Oakley?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report it, do so with recommendation that Senate File 55 do pass, and would turn over the explanation to my good fellow committee member from the western part of the state.
Representative Storer.
Thank you, Mr. Chairman. Senate File 55 is a bill that deals with the role of the Board of Equalization. The board has 2 roles. One of those roles concerns having a hearing with respect to state-assessed properties only. And that's what this bill applies to. The other role that the Board of Equalization plays is the Board of Appeals. When you have a tax case, when a property owner has appealed at the county level, and the Board the Board of Equalization acts as the appellate court. We had this bill last year. It sailed through the other end of the building, and then we got here, and there were some concerns from some of our members, and there may still be some concerns from some of our members, but this bill has not had any votes cast against it in its history. There was a slight modification in the language from last year, and that's it. What it allows this to do is act like the district court in how the Board of Equalization approaches hearings and how they issue orders. This helps save a lot of money at the state level by having this very special court instead of filling up our district courts when some of our large mineral industries have a question or have a concern about their taxes. So that's the bill. Any questions?
Any further discussion on the bill? Representative Krega.
Thank you, Mr. Chairman. Question for the bringer of the bill. So you mentioned that this only applies where it's the state is the initial party. We're talking about a trial court level. And I guess I'm wondering, because as I read that statute, I'm not sure the part of the statute we're amending actually only limits it to that. I would read it that it limits it. It also applies to the county level appeals, but if you could instruct me on that, that'd be helpful. Thanks.
Representative Storer.
Thank you, Mr. Chairman. I believe it is the language that suggests that that's included in the amendment to the statute, that this paragraph shall apply to questions related to the board's adjudicative and regulatory functions. And that's what limits it.
Chairman Swanitzer.
Thank you, Mr. Speaker. To answer the good country lawyer's question, yes, we would believe it would apply to the county level as well.
Representative Stiff.
Mr. Chairman, so this bill is slightly different from the one that we killed last year. Last year, the bill said that the board could address new issues not raised by the parties. So that really sent up alarm bells because it implicates due process, because if you're the taxpayer, you go to this board, and then you're not just fighting against the Department of Revenue, for example, you're also fighting against the judge, right? So that was a problem. And so the question is, what does this bill do? This bill takes out the issues not addressed language, but keeps the language that says the board's not limited to the interpretations of law by the parties. And it seems like that seems to be the law already. So I'm trying to figure out what mileage we get out of this bill. And specifically, the bill last year was brought in respect to a specific case involving a trona mine, where they were disputing whether the severance tax is calculated, how the severance tax gets calculated. The trona comes out to the mouth of the mine. That's where the valuation for severance tax is supposed to be calculated. But the statute says you look at the final value of the soda ash, because there's a market value for that. You know what your soda ash sells for. And then the legislature has said you deduct the industry processing costs from that final product to get to the value of the trona, and then you get taxed on that so-called industry factor. Very complicated. I don't quite understand all of that myself, but the issue there, what I'm concerned about is the bill last year would have changed the outcome in that case, okay? And my question is, would this bill also have changed the outcome or not? And if it wouldn't have changed the outcome in the case, then why do we need the bill? And if it would have changed the outcome, then I'm concerned that we have the same problem as we did last year, where you're the taxpayer, you go to court, and now you're fighting not just against the executive branch of the government, you're also fighting against the quasi-judicial board. So with all of that, I'm just interested, what does this bill really do? I can't figure out what the scope of it really is.
Representative Storer.
Thank you, Mr. Chairman. I'm going to attempt to address the questions with some help from some members of the Board of Equalization. So I think the point is that sometimes the parties both misinterpret the law or ignore a component of the law. The board must be able to consider all the statutes, the rules, and the cases that came before them, not just what the parties present in their case presentations. Every court must have the ability to consider all of the law. This is actually how the Board of Equalization has been operating for a number of years. Way back in 1996, the department was split. The department and the board's efforts were split up, and as a result, some of the statutes actually really didn't end up in the right places. The board has gone on to operate as it has for its entire history. But in the Solvay case, it became apparent that they actually did not have the authority in statute that they've been operating under for this entire time. So that's the reason for the bill.
Representative Jennings.
Thank you, Mr. Chairman. So I guess my questions would come around on line 7. Shall apply to questions related to. Doesn't seem like there's any sideboards on that. And then on line 9, when 8 and 9, when deciding questions under this paragraph, they're not limited to the legal interpretations presented by so it doesn't seem like there's any sideboards on that either. It seems like it's opening it up to the board of being able to go wherever they think the fishing might be good. Was there any talk about the chilling effect that this might have on people who want to have their requests heard about having been overtaxed or something? Was there any of that conversation? And can you talk a little more about the sideboard side of this? Because, boy, this looks like it opens it up an awful lot.
Chairman Zwanitzer.
Thank you, Mr. Chairman. So before us is the board. It's a constitutionally created entity, and their ultimate purpose is to get it right on behalf of all Wyomingites, right? Their decisions go beyond any individual case. Their job is to make sure our taxation is fair, equitable, justified, et cetera. I can pull up the constitutional section. So the issue arises when you have two parties, and it's usually a county or the Department of Revenue and an aggrieved person, and they are making, in this case, the specific case, and I don't want to use the proper name that other people did, well, I guess the honest answer is they, one side that lost had a really, really good law firm who went through and said, this is kind of a technicality loophole that we haven't explored before, so let's take it before the Supreme Court. But the question is, when you have a dispute in this case, right, and one side is saying, here's the problem, the other side is saying, here's our answer, and it goes before the Board of Equalization, they're saying, in this one case and in other cases subsequent, you actually missed something, you know, buried in these other statutes over here that aren't actually in dispute on what your tax is, you totally missed, there's another exemption, there's another credit, there's another subsidy that you could have applied for that would have exempted this and knocked out your whole problem to begin with, but you didn't talk about it. That's the issue that we're having, is when the actual dispute misses something on both sides, and the Board of Equalization says, you know, we've actually heard cases like this before, you really should have brought up point X over here, and you both forgot. What do? They say they rule on the facts. That's not really in the best interest of the entire state of Wyoming. For the rest of us, they need to be able to incorporate all of the information and what the actual correct outcome should have been by being able to utilize all of the statutes, all of the information, all of the case law that might not have been actually called attention to in any specific lawsuit. And that's the problem they found, is they always thought they had this authority until a very good law firm pointed out that you might not actually have this authority, and it went a divided opinion in the Supreme Court because it wasn't specifically stated. So they've come to us saying, we'd like it specifically stated. We'd like to be able to look at the law holistically to make sure we get it right on behalf of every taxpayer in Wyoming in every subsequent case. Because you don't want a case decided when, you know, everything wasn't taken into account. So I hope that answered some of the questions and relieved some of the fears. I'm not sure what other sideboards some of you may wish, but we could certainly talk about that on second or third reading if there's ways to drill down the language and offer some reassurances.
Representative Crago.
Thank you, Mr. Chairman. Question for the good bringer or the committee, anyone on the committee. So let's go down this rabbit hole a little bit further. Let's assume the board, equalization, gets a case, whether it's from county or state level, and says, hey, department, or hey, county assessor, we don't think you did your job right. And this is how you should have done your job. We're not deciding whether one side's right or wrong. We're deciding something completely different that was never argued about between the parties. And this is what you should have done. Because that's exactly what happened in the case that we're talking about. Exactly. So the question is that their job? This is a big policy decision, actually. I think it's bigger than we think it is. This isn't a simple little thing. And so the question is, do we want to give that ability, that authority, that power to this particular board? I think that's the question we're asking ourselves with this particular bill today. Are we allowing them, as part of their, as the good chairman said back there, as part of their equalization job, to make decisions that were never contemplated by either party, whether it be the good department that handles our revenue or our local county assessors? Are we giving them that ability? That's what we have to decide.
Representative Storer.
Go ahead.
Vice Chair Oakley.
Thank you, Mr. Chairman. So I've had, I mean, we discussed it last year, we've discussed it this year. I had the same concerns, specifically sort of the appellate level, raising new issues. And then what we heard from the Board of Equalization was that in relation to state assessed property, they do function similar to it's a trial court. It's the first time they're hearing the issues. And they said because of that, they need this ability to remand and to get full information. And so that gave me at least some understanding maybe of what they're asking for and the necessity that they believe is presented, since they feel like basically we're precluded from getting that full information on sort of the trial court level as it relates to state assessed property that they need in order to do their job fully and fairly. So that's the testimony we heard.
Representative Jennings.
Thank you, Mr. Chairman. So I guess my next question would be, what other court do we do that? Where there's a person on trial, in a way, this is a trial, and they have a lawyer, and the other side, the state, which has deep pockets, and now we're going to allow the judge or this panel of judges help out the trial lawyer or the lawyer from the state against the plaintiff. Is there another place in judicial where we do that, where the judge can say, you know what, lawyers, you forgot about this. Maybe you want to go this direction. Is there any other place where we do that?
Representative Storer.
Thank you, Mr. Chairman. My answer to that is that all courts in civil court do this in a trial. The Board of Equalization doesn't decide without letting the parties answer the questions that they pose. If they weren't allowed to do that and bring the law into the conversation and say, well, have you actually considered this or that? In many cases, they would have to kick the can down the road and come back a year later and make a decision. So this is the way that the board has been operating throughout its period of time that we've had it. And I do think that this is really just a cleanup bill that we need to put in statute. Thank you.
Representative Grego.
Thank you, Mr. Chairman. To answer the question from the good representative from House District 30, the answer is yes. Sometimes judges make suggestions or recommendations to council, but that's not really what we're talking about here. I wouldn't have a problem if it said before the decision is made that they consulted with the parties and talked about it. This is a matter of due process in my mind. What I'm saying is, if you don't get the chance to rebut the argument that the adjudicatory board is going to make, it makes it really difficult. And so, because you're going to lose, you don't even get to talk about it. And so to your question, it does happen. Judges make suggestions to us all the time, sometimes subtle, sometimes not. But at least you get the opportunity to address that. You get to make your argument on the record. I don't know if that's going to happen under this particular language. And so that's why I have some unease about it.
Representative Ottman.
Thank you, Mr. Chairman. Of course, I'm not a lawyer, but what I will say is that I have over the years watched a few instances where there was a court case going on, and I thought, why don't they ask that question? Why don't they ask that question? Why don't they ask that question? And a lot of it was because, well, that wasn't brought up and given evidence, or it wasn't put into the process to whereas it could be brought up. Okay. Another time I went to county assessor's meeting, and so there was a dispute between the taxpayer and the assessor. And so the assessor, knows what they know, and the taxpayer knew what they knew, and they could not come to an agreement. So it went before the equalization, which is the commissioners, but they brought in a gentleman that sat there, and he has experience with disputes. And he listened to both sides of the stories, and he, in his position, was able to say, well, what about this, or have you considered this, or whatever, and to be a neutral party, but bringing out the information that needed to be had by both parties to deliberate and to come to a conclusion. So I believe by watching Revenue the other morning that that is where this gentleman is trying to go with this, is that if I don't have the authority to instigate questions that would bring in more information to deliberate for both parties equally and justifiably, I can't do my job. So that's, I mean, you might dispute what I'm saying, but that's the way I saw it. And I think it's that simple, as he's not trying to get authority that he shouldn't have, but he's trying to get the authority he needs to do his job. So I would vote yes. Thank you.
Representative Chestick.
Thank you, Mr. Chairman. I think I'm hearing a lot of discussion about making an analogy to a trial court and an ordinary dispute resolution court. These boards at the state level and at the county level are a little different. When I was in practice, for a number of years I was the chief counsel for a board of tax appeal like this in a different state, but it served the same function. And it's not exactly like a trial court. It is an administrative agency. The interested parties are the taxing body itself, perhaps, the taxpayer, but also the interests of of other similarly situated entities. The whole name of this body is Tax Equalization Board. So if one appellant presents a case that results in a more favored position than other similarly situated taxpayers, that's not fair. That's not equal. So these boards need the ability to look at things beyond what the litigants present to them. And therefore, I'm very much in favor of this bill, and I think we need to pass it on. There may be some amendments that might help, but I think this is an important bill. This simply allows the board to do what it's supposed to do, and that is make sure that all taxes across all similarly situated entities are fair and equal, and that's what we should be trying to accomplish.
Chairman Olson.
Thank you, Mr. Chairman. So I do think, for comparison reasons, comparing this to a court of law is an appropriate comparison to understand the gravity of what we're talking about, because courts administer justice and fairness, and a board administers justice and fairness. Now, boards are, by design, supposed to be, when you go before an adjudicative board or an administrative board, they're designed to be a little more relaxed than a court of law. That's absolutely true. All the rules of procedure that apply in a court of law are not going to apply in front of an administrative board. However, the basic principles are the same, and I think the Good Country Lawyer really hit the nail on the head. The issue that I have with the language in this bill is that in a court of law, under the philosophy of being able to respond to what's presented is very key to a fair process. The problem with the way this is structured is that a taxpayer may present its argument, then the taxpayer may respond to an argument produced by the state or the county. And then if the board considers extrinsic evidence, the taxpayer does not have an opportunity to respond to that extrinsic evidence and prove their case otherwise. And that's the inherent flaw in the problem, when that happens in a civil court, a judge might come to the parties and say, there's an issue that I would like briefed, and the parties brief the issue. The judge may even narrow it down to a specific circumstance or even specific cases and demand that a specific rule or principle be briefed. But the whole point is that when a judge brings in outside evidence like that, the parties have an opportunity to respond to each other and present their argument before the court. That same basic philosophy should exist with the boards because it's about fairness. Now, if this bill progresses, I think we need to work on some language on a second or third reading to try to build it. You know, I think the good chairman of health talked about the ability to narrow this down and maybe have some sideboards. I think there's definitely the issue of a major sideboard, the way it's presented right now, the need for it anyway. So just urging the body some extreme caution on this, especially looking at it from the taxpayer's point of view. Thank you, Mr. Chairman.
Chairman Zwanitzer.
Thank you, Mr. Chairman, and I agree strongly with the previous speaker. So we can amend some due process, better protections into this bill. We can make sure that the questions asked by the board get to be responded to before some ultimate decision is made, so it's more transparent and fair to all parties. So I will pledge to you all get to work on that right now and hopefully have a good second reading amendment that alleviates some of the concerns in the room.
Representative Jennings.
Thank you, Mr. Chairman. So obviously, I'm having a little consternation with this particular one, and I did last time. Maybe I missed it. Was there I thought there was a definition of what was different between this year's wording and last year's, and boy, it looks awful close. I mean, it's like, well, I haven't really been able to find much difference. And so if I could have them, the bringer of the bill, explain what's different that makes this a palatable thing this year, as opposed to what we've seen in the past on this subject matter.
Representative Storer.
Thank you, Mr. Chairman. To answer that last question, my understanding is that the language that may address issues not raised by the parties and was the phrase that was taken out, so that it now reads, when deciding questions under this paragraph, the board is not limited to the legal interpretations presented by the parties. The board shall decide questions. It's worth noting that the Board of Equalization also is held to the rules of civil procedure. I think the issue is that since the Solvay decision, the board has had to decide cases incorrectly because the parties did not present the correct interpretation of the law for the board to affirm and accept. The board has in effect been required to decide which parties are less wrong. This really doesn't make sense and just causes confusion for the public and requires the parties to come back in the next year to try to get a correct adjudication.
Representative Knapp.
Mr. Chairman, thank you. I've had the opportunity to serve on several Board of Equalization decisions, and the one thing that you have to remember is that in the end, you're coming up with findings of fact and conclusions of law. That's the judgment that's rendered. So just as a judge relies on statutes, a judge relies on the Constitution, a Board of Equalization is bound to rely on the presumption that the assessor and the CAMA system is correct, just like statute or just like the Constitution. And it's the plaintiff's goal to put out evidence that would say that that CAMA system is not correct. So the fact that you rely as a member of the board on the CAMA system, you relied on what is considered statute already, is very important in that case. And you may, just like a judge, draw from your experience, the Constitution, statutes that weren't presented in a case. But that's what the Board of Equalization does.
Speaker Pro Tem Stipp.
Mr. Chairman, so earlier I had asked if this had been the law, well, 6 years ago now, would it have made a difference in that case involving that Trona company? okay? And so far, I haven't heard an answer to that, so I'll go on a limb and answer the question myself. I think that if this had been the law 6 years ago, then the Board of Equalization would have been allowed to interpret the law, because it says interpretations in this bill, interpret the law without, frankly, any notice to the parties. And the result in that case was that the Trona Company ended up paying more tax. And the details of it are, the specific mundane question was, do they get, it's more expensive to bag Trona in small amounts than to put it into a rail car, right? And what the Trona mine wanted to do was say, hey, that cost, of bagging it, we get to deduct that because you're only supposed to look at the value as the Trona as it comes, for severance tax purposes, the value as it comes out of the mouth of the mine, right? What the board did in that case was say, no, you don't get to deduct the bagging costs. And that came as a surprise to the taxpayer because both our department that deals with revenue, the taxing authority, and the Trona mine had both agreed that bagging costs were deductible. Okay, so I think this bill is strong enough that it would have changed the outcome in that case, and I think that's unfair to the taxpayer because the taxpayer then is faced with fighting against not only the government, but against the judge. And so for that reason, I'm a no on the bill. Thank you.
Question being called. All those in favor of Vice Chair Oakley's motion that when the Committee of the Whole rises to report, it does so with the recommendation that that Senate File 55 do pass. All those in favor, say aye. Aye. And those opposed? No. Senate File 55 has passed the Committee of the Whole. The next bill for our consideration is Senate File 58. The reading clerk will please read the bill.
Senate File 58, sponsored by Appropriations, Investment of State Unemployment Insurance Trust Fund, an act relating to unemployment compensation funds. Mr. Speaker, your committee number 2, Appropriations, to whom is referred Senate File 58, Investment of State Unemployment Insurance Trust Fund, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Nicholas, Sherwood, Stith, Walters, Swanitzer. Excused, Representative Larson. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Nicholas?
Thank you, Mr. Chairman. I move in the Committee of the Whole rise and report. It does for the recommendation that Senate File 58 do pass. And I turn the explanation over to good representative from this county.
Representative Henderson.
Thank you, Mr. Chairman. I bring Senate File 58 and request your favorable consideration. This bill provides for the investment of State Employment Insurance Trust Fund, amends procedures related to the payment of benefits, amending the distribution of earnings. This is a JAC bill, and fundamentally what this bill does is it takes the trust fund and moves it from the standard agency pool to the Pool A investment account to generate higher earnings. By doing this, it's estimated that it will generate a revenue increase of $800,000 in earnings per fiscal year. That's on the fiscal note. And that's assuming that 100% of the investment, 100% investment of the current fund balance, which is $51,460,891. If you turn to page 2, this is related to public funds, and what it does is it creates a new subparagraph 16. There's already 15 in there. The top of page 2 is a little context for us on what's in the statute. And it adds that authorization for 100% investment of the funds. As determined by the director of the department that administers workforce services. On page 3, line 4, this is where we get into updating the provisions related to the fund. The The director on page 3, line 7, you'll see subparagraph B there. This is a rewrite of, the director determines the timing and amounts of withdrawals from the trust fund to pay the necessary benefits. It's good to note that this is not payments to the compensation trust fund. The purpose of amending these paragraphs is to get the statute up to date. It goes on and subsection C there provides that the trust fund is dissolved. Page 3, line 22, the governor may dissolve the trust fund if he finds it unnecessary based on solvency of the unemployment compensation fund and need for Wyoming worker training. Going on to page 4, line 5, subsection provides limitation on crediting amounts from the trust fund to the workforce development training fund if the balance at the end of the fiscal year is less than the balance on July 1 of 2023. And that's a mechanism to preserve the balance of the fund. The portion of earnings from fund investment are retained until the bond balance is restored to that balance. It so happens that that balance is the same one I mentioned earlier, 51.4 million. The annual amount of earnings retained should not be less than 50% of annual earnings needed to restore the fund to that July 1, 2023 fund balance. And then the final thing is this bill is effective immediately. If there are any questions, I'd be glad to take them.
Is there any further discussion on the bill? Representative Hornock.
Thank you, Mr. Chairman. I would like a little more clarification on this. You mentioned that sometimes I don't understand this. We move an account to another account to generate more earnings. Why can't we keep that account in one spot and just invest it the same way this other account is invested so that we equal the earnings? I don't understand that. And then the second question I have for clarification, the State Unemployment Insurance Trust Fund is a fund used to pay unemployment insurance. And generally, money that comes into this fund is paid by employers throughout the state so that when there's a parting of ways with an employee, then the employee benefits come out of this trust fund, more or less. So by mixing these funds, though, moving all this unemployment insurance trust fund, which I'm curious what that dollar amount is also. You mentioned a couple numbers and I might have missed it. But by moving this big trust fund that we have to fund laid off workers into another account that's larger, are we certain that we're not mixing money? Because those insurance, the unemployment insurance funds are very specific because the employers are paying into that. So it's very specific to go to a very specific purpose. So if you could just clarify some of that stuff. And then there's something where we also, in this 273209, we delete, and I don't understand what this is, but amount withdrawn for payment of benefits, we're deleting this section, shall be immediately forwarded to the Secretary of the Treasury of the United States of America to the credit of the state's account in the unemployment trust fund. Are we then doing something that moving money around so because we're supposed to send that money to the U.S. Treasury, or just kind of a little bit more explanation on that portion?
Vice Chair Larson.
Thank you, Mr. Chairman. I think it's really important for us to understand today we're going to have this bill, and then the following bill, and we're talking about two unemployment funds. We talk, in this bill is talking about a state-required state unemployment fund, and the next bill is going to be talking about the federal fund, which I think the good representative probably was referring to in most of his comments. The history behind the one that this bill talks about was created in the 1980s when our state unemployment, when the federal unemployment fund was not real solvent, when our federally required state unemployment fund was not very stable. And so we created a state unemployment fund to do the same thing, to make sure that unemployed workers that receive their benefits as employers paid into it. In the 1990s, and I'll figure it was created in 97, and then I think in 2003, our federally required unemployment fund was healthy, solvent, second most solvent in the nation, that we didn't need the state one anymore, but we didn't need to add into it anymore. So it was set in at 50 million and has been sitting there. In the event that the federal one is depleted, we've got this 50 million sitting there that we can make sure that we pay our unemployment obligations to the employees of the state. Okay, and so that just been sitting there, kind of in this, just been sitting there. Now, the requirement for that currently is if we did have a catastrophic event that we needed to tap into that because the federal funds were not adequate, that language that he referred to that we're deleting requires the state to give that money to the U.S. Treasury, then back for redistribution. Where the agency sees the problem is it would be at the time when we have a federal shutdown and the agencies aren't working, the Treasury's not working. How do we get the money to the employees? And so that's why we deleted that language. The department now, if we have a federal shutdown and we're not getting the money to the employees, that they can do it. That they can make sure they can tap into this 50 million, make sure that that's taken care of until the federal folks are up and running again. But now the other thing we do with this 50 million here is we take the investment earnings, we reinvest it, and we're going to take these investment earnings and we're going to put them into workforce training, half of it. And then we're going to grow the corpus as well. If the value of the corpus ever drops down, they have to make sure that it stays at that 50 million and protects kind of as this insurance policy to take care of our unemployed workers in the event that our federal fund is insufficient. I hope that makes some sense.
Representative Henderson.
Thank you, Mr. Chairman. The only thing I would answer, I think was one of your questions, was the amount we're talking about. It's at 51.4 million.
I meant to.
Vice Chair Larson.
And if I may, one of the other reasons we move it, and the good representative says, well, are we commingling these funds? These are state funds. And we're taking now the state agency pool, which is like your checkbook, receiving very low interest, moving it into the pool A, which is a higher rate of return. But they're state funds, and they have to keep track of them just like they do all of the other funds.
Representative Hornock.
Thank you, Mr. Chairman. So currently in state statute, earnings off of this $50 million-ish go to workforce development and training. So that happens already, right? We're not doing anything new with this. So I'm still wondering why what's the real point of mixing these funds. It seems like if it's important enough to keep these unemployment insurance funds solvent and keep the corpus, it seems like the way we have it now is working just fine, because the earnings off of that fund go to training, and then they're available to pay unemployment right now. So I still don't see the need to transfer all of this into Pool A. Thanks.
Vice Chair Larson.
Well, we wanted, thank you, Mr. Chairman, we wanted in Pool A to earn more money to get a greater return. And then it gives flexibility on the amount, and it's just the earnings now that can be used for workforce services and not the corpus, and in a greater proportion.
Representative Henderson. Question being called. All those in favor of Chairman Nicholas's motion that when the Committee of the Whole rises to report, it does so with the recommendation that Senate File 58 do pass. All those in favor say aye. Those opposed say no. Senate File 58 has passed, Committee of the Whole. The next bill for our consideration is Senate File 59. The reading clerk will please read the bill.
Senate File 59, sponsored by Appropriations, Federal Unemployment Compensation Trust Fund Adjustment, an act relating to unemployment compensation. Mr. Speaker, your Committee Number 2 Appropriations, to whom was referred Senate File 59 engrossed. Federal Unemployment Compensation Trust Fund Adjustment. Respectfully report, same back to the House with the recommendation that it do pass. Ayes. Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Swanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure? Chairman Nicholas.
Thank you, Mr. Chairman. I move in the Committee of the Whole Rise and Report. It does so with the recommendation that Senate File 59 do pass. Now I turn the explanation over to the bill to the good representative from Laramie County.
Representative Swanitzer Dave.
Thank you, Mr. Chairman. So before you, we have Senate File 59. In a nutshell, this bill simply changes the distribution of funds from one component of the Federal Unemployment Insurance Trust Fund to allow more money to flow into the Workforce Service Development Training Account. So right now, employers, they're sending money to the Federal UI Trust Fund at a rate of 2.5 times the recommended amount. And so as a result, Wyoming, in the way of solvency of this account, they've always been in the top 3, and coincidentally this year, they're in the top spot. So what we're trying to do and accomplish with this bill is to give back a little money to the employers, and we accomplish this by changing the formula of one of the 4 components that determines the employer's contribution. So the new formula up for your consideration is found on page 2, lines 8 through 14. You'll notice that the current formula for the employee contribution is currently on this one adjustment factor is 60% going to the Unemployment Compensation Fund and 40% going to the Employment Support Fund. So what this bill will do, if you accept it, the formula will change, and now we're going to send 20% to the Unemployment Compensation Fund, 60% to the Employment Support Fund, and 20% to the Workforce Training Fund created by 922604. And so you're asking, what's the purpose of this bill? It's kind of twofold. Number one is we are giving way more money to the account than we need to, and we can't just say, hey, we've donated too much, we want it back. So what we're doing is making an attempt, and we're going to lessen our contributions to that federal fund, and then that will let us divide the other one that goes into the compensation fund and allow 20% go to the workforce services training. And I know there was some comment made on the last bill, well, why do we need more funding for workforce training? Well, number one, And the most important is that the employers of the state of Wyoming are demanding more skilled employees for their workforce. And remember, last year, the employment in the state of Wyoming is up 2.5%. We had over 6,800 new jobs. We had over 1,000 new businesses, and we had more than $1 billion in new money put into the state of Wyoming. So this is one of the ways that we're able to give back to the employers, even though it's indirectly, so we can allow them to be able to find the more qualified employees in the state of Wyoming. And with that, I would stand for any questions.
Chairman Brown.
Thank you, Mr. Chairman. I'm just curious, based off of the last bill and this bill, have we ever just thought maybe of not charging the employer so much?
Representative Warnock.
I think the last speaker kind of asked my question well. I think employers would like to see more skilled workforce, but I think employers would also demand a lower unemployment insurance rate. We have some of the highest in the state of Wyoming. It's incredibly high. It went up again this past year. So it would be nice, since we have such a solvent fund, to not look at the way we manipulate the earnings and what the earnings go to off of these funds. It would really be nice to look at ways to lower the cost for employers across the state that have to pay in to this unemployment fund. Why not? Why aren't we looking at that?
Vice Chair Larson.
Thank you. And to the good Chairman of Transportation, it's important. Now we're focusing on the federally required state and uninsurance plan. The one we talked about in the last bill, we haven't paid into since 2003. So it's just sitting there all by itself. Contrary to what we just heard from the last speaker, Wyoming has the lowest unemployment rates. And many of our employers are not required to pay unemployment per se at all. And I don't have those numbers with me, but they told us that, and one of the reasons we asked that question, so let's just give it in totality, not charge anything altogether. And there's a federal requirement it's like a % of the overall that they do, and it still makes this fund growing more than what the state needs. And so the intent of this bill is to try and maintain the solvency, stay within the federal requirements, and try and get some of this money back as possible to employers through the Workforce Training Fund. And I will get our unemployment rates back to you. I'll get that from the agency.
Chairman Nicholas.
Yeah, thank you, Mr. Chairman. Just to put that in a more simple fashion, the first question we asked was, why can't we lower the tax rate or lower the amount of contribution? The answer is because it's a federal mandate. We pay a certain amount. So we can't do that, and we can't return the funds. And so this is just making the best use of the funds as best we can within the confines that exist.
Any further discussion on the bill? Representative Hornock.
Thank you, Mr. Chairman. Just look on your computer, Wyoming, we're ranked 12th for the highest unemployment insurance so we're up there when we pay unemployment insurance. Thank you.
Any further discussion on the bill? Question being called. All those in favor of Chairman Nicholas's motion that when the Committee of the Whole rises to report, it does so with the recommendation that Senate File 59 do pass. All those in favor say aye. Those opposed, no. Senate File 59 has passed Committee of the Whole. The next bill for our consideration is Senate File 67. The reading clerk will please read the bill.
Senate File 67, sponsored by Appropriations. Public Employee Retirement Plan Contributions, an act relating to public employee retirement. Mr. Speaker, your committee number 2, Appropriations, to whom is referred Senate File 67, Public Employee Retirement Plan, Contributions. Respectfully report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Nicholas?
Thank you, Mr. Chairman. I move the committee whole rise and report. It does so with a recommendation that Senate File 67 do pass, and turn the explanation over to the good representative from the southwest corner of the state.
Speaker Pro Tem Stiff.
Mr. Chairman, yet another riveting bill about retirement contributions. This time it's the big plan. This state pension plan has 34,712 active members. Most of those are in the K through 12 education system, so thank your teachers and the like. The state employees themselves are only 20% of the active members. What does this bill do? Well, right now, as you've heard before, the plan's funded at 77% of its expected liabilities, and it's just, if we do nothing, it really just moves at a glacial pace and never gets better. What this would do is it is a half point contribution increase in year 1 and another half percentage point increase in year 2, brings it up total 1% after your 2 years, the contribution. And then what that does is it puts it on an upward trajectory so that by the year 2053, it would be funded 99.5%. So you get to, still going to be a long time. You're still 30 years out to get to basically 100%. So what does this cost your employees? What's the price tag on this? Well, for your state employees, they're going to end up paying an extra $304 in a year, so $25 a month basically. I would at this time, if it hasn't been moved, I would move the Standing Committee Amendment number 1 because that deals with how that employee portion gets paid. So, Mr. Chairman, having moved Standing Committee Amendment number 1, let's.
You've heard the motion on Standing Committee Amendment number 1. Oh. Is there any discussion on Standing Committee Amendment number 1? Question being called. All those in favor of Standing Committee Amendment number 1 to Senate File 67 signify by saying aye. Aye. Those opposed, no. That amendment has been adopted. We are back on the bill.
Great, thank you very much. So back on the bill, the employee pays 25 basis points or 0.25% in year 1. The contribution will go up by that much, and then the employer pays the other 0.25%, and then in year 2, the employees goes up again by 0.25, and the employer chips in. As a result of that, essentially what we're doing with this is getting this big plan on an even keel upward trajectory. You may have a question, how does this relate to what we did earlier with the actuarially determined contributions bill? Well, folks, I know you wanted to know, inquiring minds want to know, these bills do mesh together in the following way. If we pass both, the actuarially determined contributions bill that we talked about last week, it has a delayed effective date. It doesn't come into effect until, I believe, 2027. So then what happens is if you pass this one too, then when you get, and if we also pass the ADC bill, it means that any increase in 2027 would be very small or much, much lower, okay? So if you don't do this bill, but you did pass the actually determined contribution bill, then in 2027, the state employees could expect to see a significant bump in their expected contributions. The question is, if we want to have a sort of a level increase so they're not shocked and don't have the rug ripped out from underneath them, then please vote aye on Senate File 67. Thank you so much.
Is there any further discussion on the bill? Chairman Burkhart.
Thank you, Mr. Chairman. Just a quick question. If you look on page 2, line 14, and then I believe also on page 3, line 22, there's mention of firefighter members in the plan, and those rates weren't adjusted. Was there a particular reason for that?
Speaker Pro Tem Stiff.
Mr. Chairman, it's my understanding, we, as you may recall, we really rescued firefighter Plan A a couple of years ago by dumping $75 million of taxpayers' hard-earned money into it, that we did that. And then as a result of firefighter Plan A it looks great. It's extremely healthy. And as you might recall from a couple of years ago, what we also did with that is we said that when the firefighter A people are no longer with us, whatever's left over in the plan, and it turns out that firefighter A is now overfunded a bit, that dumps into firefighter Plan B. And so the actuaries are telling us that we don't need to change firefighter Plan B or A. That's my understanding of the state of play.
Chairman Burkhart.
Thank you, Mr. Chairman. So firefighter Plan A and B are both separate plans from the large plan. This is the large plan, and all I see is it says firefighters included in this plan, not mention of A or B. So are there firefighters in this plan?
Speaker Pro Tem Stiff.
Mr. Chairman, this, as you can tell on page 2, line 14, that's existing law. So although it's printed in this bill, we're not changing it. It's not new language. So we frankly didn't discuss that issue. What I think the correct answer is I think that firefighter Plan A is a completely separate animal for the most part and is not in this article, but firefighter Plan B is, I believe. But please consult your own attorney about that.
Any further discussion on the bill? Question being called. All those in favor of Chairman Nicholas's motion that when the Committee of the Whole rises to report, it does so with the recommendation that Senate File 67 do pass. All those in favor say aye. Aye. Those opposed, no. Senate File 67 has passed Committee of the Whole. The next bill for our consideration is Senate File 70. The reading clerk will please read the bill.
Senate File 70, sponsored by Capital Financing. Investment Modernization, State Non-Permanent Funds 2, an act relating to public funds. Mr. Speaker, your Committee Number 2 Appropriations to whom is referred Senate File 70. Investment Modernization, State Non-Permanent Funds 2. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Swanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Nicholas?
Thank you, Mr. Chairman. I move in the Committee Whole Rise and Report. It does so with the recommendation that Senate File 70 do pass. And I turn the explanation of the bill over to the good representative from Shorrock County.
Representative Walters.
Thank you, Mr. Chairman. Again, this is Senate File 70, and I'd ask for your favorable consideration and a vote of an aye when we get to the end here. But this bill really affects two accounts. It's the Cultural Trust Fund and the Wildlife Trust Fund. And so what we're doing is we're really putting into, no major changes here, but we're putting into law some things that are, and formalizing some things that we're already doing. So if you move on to page 2, we're defining what is an income account. You've heard us talk about spending from the income account of these two versus the trust side of the account. And so we define the income account. Then if you move on to page 3 in the top, now we're going to start in this bill discussing the Wyoming Cultural Trust Fund. And so the first thing we do is in lines 9 through 13, basically, we set up the income account because we've always utilized it, put money in it, but it's never been formalized. So we formally set that out. Then if you get down to line 18 and 19, and I want to point this out, we strike out the fact that this is an inviolate an account. And what we're doing in this bill for these two accounts is we're moving to a true endowment model of how these two accounts will operate. Now, don't panic because we take that away, but then in the next page, we're going to set up a spending policy for these two accounts. And so as we move on over to page 4, this is the setting up of not the spending policy, but this on page 4, the new language allows the ability of the trust fund to invest in equities. This is just the trust side of the account, not the income account in the account within the account, but just the trust side allows them to invest in equities. And I'll point out on lines 17 through 19 to strive for the highest possible risk-adjusted total net return consistent with an appropriate level of safety and liquidity. And so that's what the goal is. So there's some sideboards. And then if we move on to the bottom of page 5, this is where we set up the spending policy. And the top of page 6, it's a 3% spending policy for this particular account. And why did we select 3%? And it's really due to this small size of the trust fund. It's just under $30 million. And in visiting with our chief investment officer for the state, they explained that with a smaller total balance, you need to have a smaller spending policy to match that, because you're going to have a little bit shorter term investment, so they won't generate quite the same amount of revenue. And then if you move to the bottom of page 6 and onto the top of page 7, as we do for many of these accounts, we use a 5-year rolling average, and this is a stepped-in approach to that 5-year average, as we do for many accounts when we're setting them up. And the reason we do that is because if you start with the year 1 full roll-in, then it's really affected in tremendous ways by the previous year's direct deposits. And so, for example, both of these accounts received direct deposits a year ago. And so if you use that as your first year of the average, then it skews what your spending policy would be. So this is something we've done on many of these accounts over the years, is this stepped-in approach to the 5-year rolling average. And that's what's taking a place on bottom of page 6 onto the top of page 7. Then at the bottom of page 7, we have Romanet 2. And this is really listed on the next page, but it allows expenditures of other funds from the income account. And so the income account may receive grants. It may have funds still in there from previously appropriated projects that have just not been called upon yet. And so it makes sure that those funds are still available. And then we move on to the bottom or middle of page 8, line 14. Now we're moving on to the Wildlife and Natural Resource Trust. And we're going to do do the exact same thing, but it'll look slightly different because they were structured different in the beginning. So we'll start out with the stricken language that was similar to the Cultural Trust, where we're saying this is not an inviolate account. Again, we're moving to a full endowment process on these 2 accounts. Then at the bottom lines 12 through the end of the page, this allows them to be invested in equities just for the trust fund, again, not the income account. The investment earnings are deposited into the trust fund. And again, we have that same language, striving for the highest possible risk-adjusted total rate of return with the appropriate level of safety and liquidity. Again, sideboards there. Then we move on to the middle of page 10, and this creates the income account. There's some language in there in lines 8 through 10 covering the money that's already in the income account. So, projects have been approved and appropriated. We just had the large project bill. Those things get approved, but it doesn't necessarily mean that 100% of the income of the money is drawn out as soon as we approve those projects, or as soon as they do. And so there may be some residual money in there as those projects are still ongoing. And so it just makes sure that those funds are still accessible by the folks that would be needing those. And then moving on to the top of page 11, this is restructuring of the existing law. Actually, it's just a new layout there. Then we move on to conforming amendments on page 12, page 13, middle of the page, Romanet 2, line 10. This is the spending policy for the Wildlife and Natural Resource Trust Fund, and we set that at 4%. Again, as I discussed on the Cultural Trust, it's really based on the size of the trust fund. And so there's approximately $200 million in this one. Our chief investment officer for the state says that because it's of that significant value, going for a 4% is a very doable and achievable range. Because of its large size, they'll be able to invest in longer term investments that will have a higher rate of return. And so that's a 4% spending policy. We'll do the 5-year rolling average on page 14, just as we did on the Cultural Trust. Again, with the stepped-in approach over the next 5 years, we'll begin that averaging and that rolling average. And then on Romanet B, page 15, lines 7 through 10, this is, again, like we did on the Cultural Trust, this is allowing the expenditure of other funds in that income account. Again, grants from other folks, donations from other entities, things like that may reside in the income account, and so it just allows for the expenditures of that. And then on page 16, that's subsection C there, it's just a conforming amendment. And colleagues, and then we'll move on to page 17. Section 2, the repealers, it removes these funds from Pool A. So as I said, we are creating for these 2 funds a true endowment model. And so that they will be removed from Pool A, and that's what the repealers are. And then Section 3 really addresses any prior obligations within those accounts, just making sure that they are still accessible and still available. And all of these activities are really to generate more dollars with the same or less same amount of risk for the both of these two accounts. And so with that, friends, I would take any questions, and if there are none, I'd ask for a yes vote or an aye vote on this bill.
Representative Ottman.
Thank you, Mr. Chairman. I do have a question. With these being from CapFin and appropriations and Senate files, are there mirror bills on the House side? And also, are all of these, have these investments been supported by our state treasurer?
Representative Walters.
Thank you, Mr. Chairman. Thank you for the question. These bills are just like any other bill with the exception of the budget bill. The only bill that is mirrored between the two bodies is the budget bill. All other bills start in one side of the House, one side of the Capitol, and travel to the other through the process. This one happens to be sponsored by the Select Committee on Capital Finance and Investment. That committee is not a standing committee, it's a select committee. So during the session, that committee does not meet. And so the committee number 2 is the committee that our good speaker happened to point this out to. And so we heard it on committee number 2 on the House side. And so it just goes through like the process like any other bill would. So I hope that answers that question. As to the question about our chief investment officer and supporter or whatnot, I don't think it's appropriate for this body to say if any of those folks support or don't support things, but I can tell you through the select committees meetings and whatnot, the chief investment officer of the state of Wyoming, as well as his folks that work with him, were in all of these meetings, helping us craft all of these bills, very involved, saw great potential in this bill, and recognized that this bill will allow them to do just what I read to you a short time ago, to strive for the highest possible risk-adjusted total net return consistent with appropriate level of safety and liquidity on these two accounts. And that's what was recommended to us by our chief investment officer for the state of Wyoming. So these ideas, while they may have been sponsored by the select committee and then vetted through the committee number 2, they really originated with our chief investment officer, and that's where these ideas have came from, and their recommendations on how to make Wyoming dollars work harder for Wyoming people without increasing the level of risk.
Any further discussion on the bill?
Please vote aye.
Question being called. All those in favor of Chairman Nicholas's motion that when the committee of the whole rises to report, it does so with the recommendation that Senate File 70 do pass. All those in favor say aye. All those opposed, no. Senate File 70 is passed, committee of the whole. I believe we have a privilege of the floor. Representative Larson.
Thank you, Mr. Chairman. Privilege of the floor, if I may.
Go ahead.
Thank you, folks. I'd just like to take you back to the Senate File 59 that we talked about, the federal unemployment tax, because as we get ready for second reading amendments and third reading amendments, just want to clarify back from the agency the conversation on the status of our unemployment taxation. And what we found out that was in 2022, for the first time in the history of our federal unemployment tax, the minimum tax rate for employers was 0%. The tax rate remained at 0% for 23 due to the health of the trust fund, which is measured by the solvency rate. We're number 1 in the nation at the solvency rate of 2.18. So what that means is an experienced rated employers with no benefit charges in immediately preceding 3 fiscal years paid 0 taxes for both 22 and 23. Hope that clarifies a little bit of that. Thank you, Mr. Chairman.
Mr. Majority Floor Leader.
Thank you, Mr. Chairman. I move the committee of the whole rise and report.
You've heard the motion. All those in favor say aye. And those opposed? The motion carries.
The reading clerk will read the committee of the whole report.
Mr. Speaker, your committee of the whole, having had under consideration bills on general file, Begs leave to report as follows. Senate File 38, do pass. Senate File 45, do pass. Senate File 47, do pass amended. Senate File 48, do pass. Senate File 49, do pass. Senate File 60, do pass. Senate File 81, do pass. Senate File 12, do pass. Senate File 18, do pass. Senate File 36, do pass. Senate File 55, do pass. Senate File 58, do pass. Senate File 59, do pass. Senate File 67, do pass amended. Senate File 70, do pass. Representative Singh, Chairman.
I move the adoption of the Committee of the Whole report.
Just a second. Chairman Singh.
Thank you, Mr. Speaker. I move the adoption of the Committee of the Whole report.
You have heard the motion. All those in favor say aye. All those opposed? Motion carries. Congratulations, Chairman Singh. All right, ladies and gentlemen, we're at that order of business of signing enrolled acts. So kind of the way the script goes, the House and the Senate try to keep up with their signatures on it. So we've completed a few bills. And so the reading clerk will read the enrolled act for House Bill 73. Is that how I do it? All right. Okay, right. All right, the reading clerk will read Enrolled Act 1, being original House Bill 73.
House Enrolled Act 1, being original House Bill 73, an act relating to environmental quality, creating the long-term abandoned mine reclamation account, specifying permissible uses of the account, authorizing investment of the funds in the account, specifying the limit of liability for the funds in the account, repealing the abandoned mine lands fund balancing account, specifying transfers of the funds from repealed accounts, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign Enrolled Act Number 1, being original House Bill Number 73. I have so signed. The next enrolled act for our consideration is Enrolled Act Number 2, being original House Bill 72.
Enrolled Act Number 2, being original House Bill 72, an act relating to workers' compensation, authorizing consideration of specified investment earnings for the determining rates under the workers' compensation program, conforming provisions for the actuarially reasonable provision for adverse deviation, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign Enrolled Act Number 2, being original House Bill Number 72. I have so signed. The next enrolled act for our consideration is Enrolled Act Number 3, being original House Bill Number 71.
House Enrolled Act 3, being original House Bill 71, an act relating to economic development, authorizing the use of broadband development sub-account funds as matching grant funds and for administrative expenses as specified and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act Number 3, being original House Bill Number 71. I have so signed. The next enrolled act for our consideration is Enrolled Act Number 4, being original House Bill 46.
House Enrolled Act Number 4, being original House Bill 46, an act relating to courts, amending the timeline for the effective and expeditious resolutions of disputes filed in the Chancery Court, specifying applicability and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign Enrolled Act Number 4, being original House Bill Number 46. I have so signed. Congratulations, Representative Walters. The next enrolled act for our consideration is Enrolled Act Number 5, being original House Bill 40.
House Enrolled Act 5 being original House Bill 40, an act relating to school district trustees, clarifying when school district trustees are required to take the oath of office and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign Enrolled Act Number 5, being original House Bill Number 40. I have so signed. The next enrolled act for our consideration is Enrolled Act Number 6, being original House Bill Number 27.
House Enrolled Act 6 being original House Bill 27, an act relating to adult protective services, requiring law enforcement to notify the Department of Family Services upon receiving a report of a vulnerable adult in need of potential protective services, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign Enrolled Act Number 6, being original House Bill 27. I have so signed. The next enrolled act for our consideration is Enrolled Act Number 7, being original House Bill 26.
House Enrolled Act 7 being original House Bill 26, an act relating to adult protective services, extending the effective period of emergency protective services and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act Number 7, being original House Bill 26. I have so signed. The next enrolled act for our consideration is Enrolled Act Number 8, being original House Bill Number 23.
House Enrolled Act 8 being original House Bill 23, an act relating to motor vehicles, confirming the ability of county treasurers to provide vehicle certificates of registration in electronic form as specified, amending requirements for the display of vehicle registrations, license plates, validation stickers, and permits as specified, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act Number 8, being original House Bill Number 23. I have so signed. Congratulations, Representative Larson, JT. The next enrolled act for our consideration is Enrolled Act Number 9, being original House Bill 21.
House Enrolled Act 9 being original House Bill 21, an act relating to K-9 or K-12 school facilities, repealing the requirement that charter schools operate successfully for 3 years to receive reimbursement for leasing expenses, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act Number 9, being original House Bill Number 21. I have so signed. The next enrolled act for our consideration is Enrolled Act Number 10, being original House Bill 16.
House Enrolled Act Number 10 being original House Bill 16, an act relating to state lands, removing the inconsistent legal description of the Sutton State Archaeological Site, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign Enrolled Act Number 10, being original House Bill 16. I have so signed. The next enrolled act for our consideration is Enrolled Act Number 11, being original House Bill 11.
House Enrolled Act 11 being original House Bill 11, an act relating to state lands, removing specific types of payments for land lease payments, amending the process for how state land lease payments are made, providing that the state land lease renewals and rental payments are considered filed on the date of the renewal or rental is postmarked, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign Enrolled Act Number 11, being original House Bill 11. I have so signed. The next enrolled act for our consideration is Enrolled Act Number 11, being original House Bill 10.
House Enrolled Act 12, being original House Bill 10, an act relating to state lands, authorizing the Director of the Office of State Lands and Investments to grant state land leases additional time to renew their leases and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign Enrolled Act Number 12, being original House Bill 10. I have so signed. The next enrolled act for our consideration is Enrolled Act Number 13, being original House Bill Number 8.
House Enrolled Act 13, being original House Bill 8, an act relating to motor vehicles, specifying that a driver who has attained 18 years of age may receive a hazardous materials endorsement for a commercial driver's license, requiring rulemaking and providing for an effective dates, being enacted by the legislature of the state of Wyoming.
I am about to sign Enrolled Act Number 8, being original House Bill Number 8. Excuse me, I'm about to sign Enrolled Act Number 13, being original House Bill Number 8. I have so signed. The next enrolled act for our consideration is Senate Enrolled Act Number 1, being original Senate File 17.
Senate Enrolled Act 1, being original Senate File 17, an act relating to the plane coordinate system, updating the plane coordinate system for Wyoming, providing for the use of other datums, systems, and networks for the system, providing definitions, making conforming amendments, repealing provisions related to obsolete coordinate standards, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Senate Enrolled Act Number 1, being original Senate File Number 17. I have so signed. The next enrolled act for our consideration is Senate Enrolled Act Number 2, being original Senate File Number 15.
Senate Enrolled Act 2, being original Senate File 15, an act relating to defense forces and affairs, authorizing the governor to accept retrocession over military reservations and lands as specified, correcting obsolete references, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Senate Enrolled Act Number 2, being original Senate File Number 15. I have so signed. The next enrolled act for our consideration is Senate Enrolled Act Number 3, being original Senate File 4.
Senate Enrolled Act 3, being original Senate File 4, an act relating to firemen pensions, allowing retired firefighters to be rehired while continuing to receive retirement benefits and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign Senate Enrolled Act Number 3, being original Senate File Number 4. I have so signed. Messages from the Senate.
Message 211. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 8, Commercial Driver's License Hazardous Materials Endorsement. Ayes 31. Message 212. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 10, Grace Period, State Land Lease Renewals. Ayes 29, Conflict 2. Message 213. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 11, State Land Lease Amendments. Ayes 29, Conflict 2. Message 214. Mr. Speaker, the House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 31. The Senate respectfully asks the House to concur by adopting the listed amendments. Message 215. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 16, Sutton State Archaeological Site Legal Description. Ayes 31. Message 216. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 21, Charter School Leasing. Ayes 30, noes 1. Message 217. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 23, Vehicle Registration E-Certificate and Grace Period. Ayes 31. Message 218. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 26, Emergency Protective Services, Effective Period. Ayes 20, noes 11. Message 219. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 27, DFS and Law Enforcement Cross-Reporting. Ayes 21, noes 10. Message 220. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 40, School District Trustee, Oath of Office. Ayes 31. Message 221. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 46, Chancery Court Timeline for Resolution of Disputes. Ayes 26, noes 5. Message 222. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 71, Broadband Development Subaccount Amendments. Ayes 19, noes 12. Message 223. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 73, Abandoned Mine Reclamation Accounts. Ayes 28, noes 3. Message 224. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 72, Workers' Compensation Provision for Adverse Deviation. Ayes 31. Message 225. Mr. Speaker, the Senate did concur on House amendments to the bill listed below by the vote indicated. Senate File 3, State Employee Leave for Volunteer Fire or Volunteer EMS. Ayes 24, noes 1, excused 6. Message 226. Mr. Speaker, the Senate did concur on House amendments to the bill listed below by the vote indicated. Senate File 30, Influencing Jurors and Witnesses, Judges Amendment. Ayes 28, noes 1, excused 2. Message 227. Mr. Speaker, Senate File 20, Electricity Rates for Costs That Do Not Benefit Wyoming. The Senate failed to concur on House amendments to the bill listed above by the vote indicated. Ayes 1, noes 30. Message 228. Mr. Speaker, the Senate appointed Senate conferees to meet with the Light Committee Number 1 from the House on amendments to Senate File 20. The Senate conferees are Senator Case, Chairman, Senator Anderson, Senator Rothfuss. Message 229. Mr. Speaker, Senate File 2, Legislative Budget. The Senate failed to concur on House amendments to the bill listed above by the vote indicated. Noes 31. Message 230. Mr. Speaker, the Senate appointed Senate conferees to meet with the Light Committee Number 1 from the House on amendments to Senate File 2. The Senate conferees are Senator Hicks, Chairman, Senator Barlow, Senator Ellis. Message 231. Mr. Speaker, the Senate adopted the Committee of the Whole report, failing the bill listed below by the vote indicated. House Bill 30, Controlled Substances Act, Possession Amendments. Ayes 13, noes 18. The bill has been indefinitely postponed. Sincerely, Ellen Thompson, Senate Chief Clerk.
So, ladies and gentlemen, we're at that order of business of request to concur with Senate amendments to House bills. So if you look on the calendar, it looks to me like on the calendar, you go to the bottom, there's concurrence. Or if you go to the bill itself, you can find the concurrence there. And so the first message and the only message for our consideration is message number 214 on House Bill 14, Chairman Zwanitzer.
Thank you, Mr. Speaker. make sure I remember how to do this. Let me move concurrence on message 214 to House Bill 14 and ask for your aye vote.
Okay, just a second. Has everybody pulled it up? You've been able to find it okay? Everybody good? All right, I'm not seeing any nose shake. Okay, at least I get a thumb up. We'll go for it. Chairman Zwanitzer.
Thank you, Mr. Speaker, and it's an easy explanation. Again, this is on the prior authorization bill that your Labor, Health, and Social Services Committee spent all year on, and finally got to a place where all of the interested parties agreed with the bill moving forward. Our good friends down the hall really only did 3 amendments. It looks a little bit longer because of the renumbering. The main amendment, they deleted the legislative findings, and as many of you know, we rarely put findings in legislation. However, the interim committee and the work group of all the industries felt it was best to keep those findings. As you saw in the House, the Senate disagreed with that and stripped them out. Doesn't affect the rest of the bill at all, just does delete the legislative findings. Our good board that deals with medicine in the state did have a quick definition amendment there on page 10, line 15. You'll just see it says, unless otherwise required under Wyoming law, and this is regards to who can practice in our state. And then they had one quick cleanup on page 20. We had the word physician. Elsewhere in the bill, it does say provider. We're changing all of our statutes lately to include physician assistant and nurse practitioner. So those are only 3 changes. All of the other lines you'll see are just renumbering the rest of the act after they deleted the findings. Be happy to answer any questions. Otherwise, ask for your aye vote.
So this is like second or third reading, you'd have 2 shots. Anybody? All right. We're voting on the motion to concur with Senate amendments to House Bill 14. A majority of the elected members is required. The chief clerk will please call the roll.
Allemand? Allred? Andrew? Andrew?
Excuse.
Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Chadwick? Chestick? Clauston? Conrad? Crago? Davis? Eklund? Haroldson? Harshman? Heiner? Henderson? Hornock? Jennings? Knapp? Larson Lloyd? Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrup? Oakley? Oakley?
Excuse.
Obermueller? O'Hearn? Olson? Ottman? Pendergraft? Penn? Provenza? Rodriguez-Williams? Sherwood? Singh? Slagle? Smith? Stith? Storer? Strzok? Stivar? Tarver? Trujillo? Walters? Ward? Washut? Western? Winter? Wiley? Yin? Zwanzer Dan? Zwanzer Dave? Speaker Summers? Andrew?
Excuse.
Oakley? Are there any changes? Closing vote. Vote closed. 61 aye, 1 excused.
By your vote, you have voted to concur with Senate amendments to House Bill 14. All right. I don't think we have any reports from standing committees, do we? We do? All right, reports from standing committees. And before I do that, I have some conference committees to appoint. Okay, the conference committee on message 228, which is the amendments to Senate File 20. The conferees are Olson Chair, Wiley, and Haroldson. Conferees on message 230, that would be the conference committee number 1. On Senate File 2 would be Zwanitzer Dan, Chair, Stiff Yin. All right. We are now at reports from standing committees.
Senate File 7, sponsored by Labor, Behavioral Health Redesign, Vulnerable Adults, an act relating to public health and safety. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 7, Behavioral Health Redesign, Vulnerable Adults. Respect the report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Chadwick, Klauston, O'Hearn, Trujillo, Yin, Zwanitzer. Noes, Representatives Hornock, Penn, Ward. Representative Zwanitzer, Chairman. Senate File 22, sponsored by corporations. Public Service Commission, Electricity Reliability, an act relating to public utilities. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate File 22 engrossed. Public Service Commission, Electricity Reliability, respect the report, same back to the House with the recommendation that do pass. Ayes, Representatives Chadwick, Haroldson, Harshman, Knapp, Newsom, Olson, Ottman, Wiley. Noes, Representative Yen. Representative Olson, Chairman. Senate File 32, sponsored by Judiciary. Hemp Limitations on Psychoactive Substances, an act relating to hemp production and controlled substance. Mr. Speaker, your committee number 1, Judiciary, to whom is referred Senate File 32, Hemp Limitations on Psychoactive Substances. Respect the report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chestick, Crago, Haroldson, Jennings, Oakley, Rodriguez-Williams, Washit. Noes, Representatives Nemec, Provenza. Representative Washit, Chairman. Senate File 34 is sponsored by Judiciary. Sex offender registration, registrable offenses, an act relating to criminal procedure. Mr. Speaker, your committee number 1, Judiciary, to whom is referred Senate File 34 engrossed. Sex offender registration, registrable offenses. Respect the report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Chestick, Crago, Haroldson, Nemec, Oakley, Rodriguez-Williams, Washit. Noes, Representatives Jennings, Provenza. Representative Washit, Chairman. Senate File 44 is sponsored by Minerals. Limited Mining Operations Amendments, an act relating to environmental quality. Mr. Speaker, your committee number 9, Minerals, Business, and Economic Development, to whom is referred Senate File 44 engrossed. Limited Mining Operations Amendments. Respect the report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Banks, Burkhart, Conrad, Heiner, Knapp, Larson, Lawley, Tarver, Western. Representative Burkhart, Chairman. Senate File 50, sponsored by Blockchain. Unincorporated Nonprofit DOAs, an act relating to corporations. Mr. Speaker, your committee number 9, Minerals, Business, and Economic Development, to whom is referred Senate File 50, Unincorporated Nonprofit DAOs. Respectful report, same back to the House with the recommendation that do pass. Ayes, Representatives Banks, Burkhart, Conrad, Larson, Lawley, Tarver, Western. Noes, Representatives Heiner, Knapp. Representative Burkhart, Chairman. Senate File 61, sponsored by Senator Driscoll. Education Charter School Amendments, an act relating to charter schools. Mr. Speaker, your committee number 4, Education, to whom is referred Senate File 61 engrossed. Education Charter School Amendments, respect the report, same back to the House with the recommendation that it do pass. Ayes, Representatives Allred, Andrew, Berger, Brown, Klauston, Lawley, Northrup, Obermueller, Provenza. Representative Northrup, Chairman. Senate File 66, sponsored by Water. Water Exchange Amendments, an act relating to water. Mr. Speaker, your committee number 9, Minerals, Business, and Economic Development, to whom is referred Senate File 66 engrossed. Water Exchange Amendments. Respect the report, same back to the House with the recommendation that it do pass. Ayes, Representatives Banks, Burkhart, Conrad, Heiner, Knapp, Larson, Lawley, Tarver, Western. Representative Burkhart, Chairman. Senate File 79, sponsored by Senator Barlow. Malt Beverage Franchise Agreements, an act relating to malt beverages. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate File 79, Malt Beverage Franchise Agreements. Respect the report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chadwick, Haroldson, Harshman, Knapp, Newsom, Olson, Ottman, Wiley, Yen. Representative Olson, Chairman. Senate File 115, sponsored by Senator Baldwin. Behavioral Health Redesign, Amendments 2. an act relating to public health and safety. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 115, Behavioral Health Redesign, Amendments 2, respectively report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chadwick, Clauston, O'Hearn, Trujillo, Yin, Zwanitzer. Noes, Representative Warnock, Penn, Ward. Representative Zwanitzer, Chairman.
All right. Chief, does that clear the deck? All right. Mr. Majority Floor Leader.
Mr. Speaker, I move the House stand adjourned until tomorrow at 10 a.m., the 29th day of February 2024, Leap Day.
Committee announcements. Chairman Newsom.
Thank you, Mr. Speaker. Your travel, committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, will meet tomorrow upon noon recess, and I'm asking my committee to quickly get your lunch so that we can get started about 12:15. We have 5 bills. Senate File 125, Parimutuel Wagering Activities Amendments. Senate File 118, Bighorn and Domestic Sheep Relocation Federal Action. Senate File 109, Prohibit Red Flag Gun Seizure Act. Senate File 111, Mule and Whitetail Deer Separate Hunting Seasons. That will be as time allows, as will Senate File 72, Utility Donations, as time allows. Thank you.
Chairman Washington.
Thank you, Mr. Speaker. Your committee number 1, Judiciary, will be meeting at 7:30 on Friday morning for 3 bills, Senate File 36, Senate File 53, and Senate File 73.
Chairman Eklund.
Mr. Speaker, your Ag Committee will meet at 8 o'clock tomorrow morning. We will work Senate File 14 engrossed, Senate File 13 engrossed, and Senate File 103, and Senate File 83 engrossed if we have time.
Chairman Brown, and when you get done, would you mind coming up here, please? Thanks.
Yes, sir. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, meet tomorrow upon noon recess to hear 4 bills, if possible. Senate File 113, Light and High Profile Vehicle Closures. Senate File 89, Veterans Ad Valorem Exemption Amount. Senate File 96, Trust and Bank Assets and Bankruptcy Clarification. And Senate File 74, Special Districts Reversal of Dissolution for Noncompliance.
Vice Chair Oakley.
Thank you, Mr. Speaker. Your committee number 2, Revenue, will meet in the morning, get a sleep in till 8:15. We'll hear 2 bills, Senate File 54 engrossed, homeowner tax exemptions, more tax exemptions, and Senate File 68 engrossed, tangible personal property tax exemptions.
Chairman Nicholas.
Thank you, Mr. Speaker. Your JCC will continue its deliberations. We haven't quite gone through all of the budget amendments, so we'll do that immediately on adjournment. And then tomorrow at noon, I believe, we will hear Senate File 90 and Senate File 64. And any other re-referrals if we have any. Actually, that's upon adjournment, not at noon. Thank you. So I think the current plan is, depending on what happens tonight, we will meet at 12:30 for JCC tomorrow.
Any other chairman? All right, you've heard the majority floor leader's motion. All those in favor say aye. Aye. All those opposed? We stand adjourned until 10 a.m. tomorrow, Thursday, February 29th, 2024.
How was your trip to the governor's office?